She noticed the mold in her bathroom first. Black patches spreading across the wall, a persistent musty smell, her children waking up with respiratory problems she couldn't explain. She did everything right, she documented it, she notified her landlord in writing, she asked for repairs. And then her landlord served her with an eviction notice. Not a repair crew, an eviction notice. What happened next in court is a story every renter in America needs to hear, because the legal principle it illustrates could protect you from the exact same thing happening to you. Welcome back to Plain Verdict. Let's get into it. Mold is one of the most common and most serious habitability problems in rental housing across the United States. It causes respiratory illness, worsens asthma, and can make a home genuinely dangerous to live in, particularly for children and elderly tenants. But what makes mold cases truly disturbing is what sometimes happens when tenants report it. Instead of getting repairs, they get retaliation. Today we're telling the story of a real mold retaliation case, what happened, what the law says, and what every tenant needs to know to protect themselves. The situation we're describing today is drawn from documented cases across the United States, cases that share the same devastating pattern. A tenant moves into what appears to be a normal rental home. Over time, moisture problems develop, from leaking pipes, inadequate ventilation, or water intrusion through walls and ceilings. Mold begins to grow, slowly at first, then spreading through walls, under sinks, behind appliances. The health consequences follow. Children develop asthma. Adults experience persistent respiratory infections, fatigue, and symptoms they can't attribute to anything else. In one documented Delaware case, a jury heard how 2 women suffered serious health consequences after their landlord neglected to fix leaks they had reported, ultimately awarding them just over $1 million in damages. In California, case after case, courts have seen the same pattern: tenants reporting mold, landlords ignoring it, and families paying the price with their health. In the strongest mold cases, tenants do everything right. They photograph the mold thoroughly with date stamps. They send written notice to their landlord by certified mail documenting the problem and requesting repairs. They contact their local housing authority or health department to trigger an official inspection, creating an independent official record of the violations completely separate from their own communications. They get professional mold testing done. They document the health consequences with medical records. This paper trail is everything in a mold case. Courts consistently find in favor of tenants who have documented their efforts carefully and against landlords who received clear notice and failed to act. In one California case, a landlord's own testing confirmed the severity of a mold problem, and then management disregarded the recommendations of the professional remediation company they had consulted, even though fixing it would have cost only a few $1,000s. The resulting lawsuit cost them significantly more. Here's where these cases take the turn that should outrage every renter. Instead of making repairs, some landlords respond to mold complaints with retaliation. An eviction notice served shortly after a written complaint. A sudden unexplained rent increase. Harassment designed to make the tenant want to leave. These tactics exist because some landlords calculate that intimidating a tenant into silence or departure is cheaper than fixing the problem. What those landlords are gambling on is that the tenant doesn't know the law, because the law on this is absolutely clear. In California, Civil Code Section 1942.5 explicitly makes retaliatory eviction illegal. If a landlord tries to evict you, raise your rent, or otherwise punish you because you reported a mold problem or any other habitability issue, that landlord is breaking the law. And California is not alone. Most states have explicit anti-retaliation statutes that prohibit landlords from taking adverse action against tenants who exercise their legal right to report unsafe conditions. The legal presumption in many states is that any negative action taken by a landlord within a certain period, often 60 to 180 days, after a tenant reports a habitability problem, is presumed to be retaliatory. That presumption shifts the burden to the landlord to prove their action was justified. Let's break down exactly what the law says. Mold is a habitability violation under the implied warranty of habitability that exists in every U.S. state. A landlord who knowingly allows toxic mold to persist in a rental property is breaching their fundamental legal obligation to maintain habitable conditions. Tenants who report mold and face retaliation have multiple legal remedies available simultaneously. Rent withholding, paying rent into an escrow account until repairs are made, is legally protected in many states when a landlord fails to address habitability violations. Repair and deduct, some states allow tenants to hire a professional to fix the problem and deduct the cost from rent up to a statutory limit. Constructive eviction, if the mold makes the property genuinely uninhabitable, a tenant may be able to terminate their lease and leave without penalty. Civil lawsuit, Tenants can sue for actual damages, including medical bills, lost property, relocation costs, and pain and suffering. And in cases of deliberate disregard for tenant safety, courts can award punitive damages. Real cases have resulted in a $103,000 jury verdict in Oregon for a tenant whose landlord ignored a reported leak that caused mold, a $500,000 settlement in California for a family exposed to toxic mold over several years, and over $1 million awarded in a Delaware case where 2 women suffered serious health consequences from landlord-neglected mold. When tenants fight back against mold retaliation and when the consequences for landlords go beyond just the damages awarded, courts can order landlords to make the repairs, pay the tenants' legal fees, pay additional damages specifically for the retaliatory conduct, and in egregious cases face punitive damages designed to punish deliberate disregard for tenant safety. The message these cases send is consistent and clear. Retaliating against a tenant for reporting unsafe conditions is not just morally wrong, it is legally dangerous and financially catastrophic for any landlord who tries it. The tenants who knew their rights, documented their cases carefully, and stood their ground in court didn't just win their own cases. They reinforced the legal protections that every renter in America benefits from today. If you're dealing with mold in your rental right now, here's exactly what to do. Step 1. Document immediately and thoroughly. Photograph every affected area with date stamps. Video walk through the entire apartment. The more comprehensive your documentation, the stronger your legal position. Step 2. Notify your landlord in writing by certified mail. Describe the mold problem specifically. Request professional remediation within a reasonable time frame, and keep a copy of everything. Step 3. Contact your local housing authority or health department and request an official inspection. This creates an independent official record that carries significant weight in any legal proceedings. Step 4. See a doctor and document any health impacts. Medical records connecting your health problems to mold exposure are powerful evidence in any subsequent legal action. Step 5. If you face any negative action from your landlord after reporting an eviction notice, a rent increase, reduced services, or harassment, contact a tenant rights organization or legal aid society immediately. That negative action may well be illegal retaliation, and you have legal options to fight back. Mold is not a minor inconvenience. It is a serious health hazard that landlords are legally required to address. And retaliating against tenants who report it is not just wrong, it is illegal in virtually every state in the country. The tenants who know this and document their cases carefully are the ones who win. If this video helped you subscribe to Plain Verdict, we cover a new legal concept or court case every week in plain language. And if you're dealing with mold or retaliation from your landlord right now, drop your situation in the comments. We read every single one.